coming from at this point in time. What's your position?
First of all, thank you for the opportunity to address this very important First Amendment issue. It is a basic First Amendment principle of open courtrooms in America, and that cannot be compromised. Any order prohibiting the press or the public from observing or discussing matters that are in an open court, especially in a criminal court, cannot be agreed to, especially by the press.
All right, well, I understand that. I mean, I understand that. It's a prior restraint that also puts the press in a difficult situation because you're trying to hold information in a bottle and agreeing to hold information in a bottle when you can't tell how porous the bottle is. So I certainly understand your position, and I believe you're right as it relates to the prior restraint.
So does that affect the press, the Eagle Tribune, of any length in this trial?
No, I understand, and what I was trying to do was twofold. It wasn't just to try and keep the courtroom open, quite frankly. It was also because I have to make a finding under Waller versus Georgia that the closure's no broader than is necessary. So what my intention would be, although I'm sorry. So what my intention would be, although I'm going to wait till tomorrow to make a decision. Be happy to hear from you now, the Commonwealth now, or the defendant now. But what I expect I'm probably going to do is close the courtroom for those 13 questions after a Sixth Amendment colloquy with the defendant. The 13 questions would be impounded, and as soon as the case gets to the jury, the interveners could move to unimpound the 13 questions and hire a witness to rebut the testimony that the court's heard, and then I would make a decision. And I understand there has to be an advocacy purity to this position. I really do. And since there has to be an advocacy purity to the position to argue for a higher principle, I expect what I'll do is ask Ms. Regan, Ms. Oker, I'm going to ask Ms. Regan to, number one, make it clear when there's going to be such a question, because the closure can be no broader than is necessary. And number two, I'm not going to require, but request that she see if there can be a segregated portion of her questioning. All right. Does the Commonwealth wish to be heard further?
Your Honor, just a quick. We really appreciate your compromised position, given the complexities of what we have. But I guess I need to understand if there are 13 questions approximately that Attorney Reagan is going to be asking, and there are 200 and some odd questions that are in the test. Will those in fact affect the integrity of such a large body of information if the questions are so narrow? And I know that you, like I, Your Honor, are in that same boat, that we don't know we are not experts in this field, but it just seems that to have 13 or so questions of a body that is so great, and for the public to be excluded, seems to me, and Your Honor has progressed, that in fact the testimony has been that this testimony would affect the health industry of the United States of America. That's pretty broad. And again, I'm not here, I'm not an expert, and I'm sure that the district attorney who has just jumped up is going to address my issue.
If you could, please.
Ms. Regan indicated she would have at least 10 questions on the MFAS, which contains a grand total of 25 questions.
10 out of 25?
Yes.
Okay. Those of us in the bar don't like to do math, but I think that's 40%.
And Your Honor, I had actually jumped up, not in response to Mr. Crusoe. I happened to be up when he said something, but to clarify so I can set expectations for the family, closure would include everyone. Is that correct? Not just the media?
It has to. I'm sorry?
That's what I just wanted to clarify so I don't give misinformation.
Okay. All right. Ms. Oker, did you want to add anything? All right. So if tomorrow morning you could have Ms. Regan address if she's able to put that line of questioning into one area, that would be helpful. Oh, okay. And I'm going to obviously need to explain with as little information as possible to the jury that I've made a decision for certain questions to close the courtroom, and I'll need to do I don't need to do a colloquy based on the Commonwealth versus Cohen case law because there can be attorney waiver, but I don't want to cause Mr. Sullivan any consternation tomorrow when, so I'm going to do a colloquy as it relates to Cohen. Okay, thank you very much. Court will be in recess.